Thank you. Welcome to the Environmental Law Institute. My name is Caitlin McCarthy, and I'm the Director of the Associates Program here at ELI. You have joined us for Law and Policy of Products Regulation, part of ELI's annual summer school series. We're delighted to welcome everyone here today in person and online, and you can go to eli.org for future events and seminars. For our audience members on GoToWebinar, we encourage you to ask a question by submitting it through GoTo's question box. And please do not hold your questions until the end. Send them as soon as you think of them. For our audience in the room, we'll use this microphone at the end for Q&A. I'd like to thank our wonderful panelists for being here today to teach the law and policy of products regulation. A recording and a PowerPoint of today's seminar will be available on our website within the next week. Full speaker bios are always posted on our website, eli.org, but I would like to take a moment to introduce our outstanding panelists. Lynn Bergeson is the managing partner at Bergeson & Campbell PC and a leading expert on this topic. As the owner of Bergeson & Campbell, Lynn Bergeson has earned an international reputation for her deep and expansive understanding of the Toxic Substances Control Act, the Federal Insecticide, Fungicide, and Rodenticide Act, European Union Registration, Evaluation, Authorization, and Restriction on Chemicals, and especially how these regulatory programs pertain to nanotechnology, industrial biotechnology, synthetic biology, and other emerging transformative technologies. Her knowledge of and involvement in the policy process allows her to develop strategies, whether advocating before Congress, the EPA, or the Food and Drug Administration, or other governance and standard-setting bodies. Lynn counsels corporations, trade associations, and business consortia on a wide variety of issues pertaining to chemical hazard exposure and risk assessment, risk communication, minimizing legal liability, and evolving regulatory and policy matters pertinent to conventional, bio-based, and nanoscale chemicals, particularly with respect to TSCA, FIFRA, Food Quality Protection Act, REACH, and REACH-like programs, and occupational safety and health administration matters. Lynn received her JD from Columbus School of Law at Catholic University and her BA magna cum laude from Michigan State University. So glad you could join us, Lynn.
Thank you, Caitlin. Appreciate it. Thank you for that introduction. You know more now than you wanted to. But anyway, why don't we jump right in? What I would like to do is, number one, tell you all what a fabulous organization the Environmental Law Institute is, its writings, its products, its programs, and if everyone in this room is not now a member or a contributor, it should be. Okay, enough of that. Number two, I want to make sure that everything I tell you here today is just treetops, because the space in Coccyx, both industrial chemicals and agrochemicals, is enormous and growing by the minute. So we have a very content-driven website. We have 4 blogs, 2 devoted, one each to TSCA, the other to FIFRA, another one to bio-based chemicals, and another one to nanotechnology. Because what we love to do at our firm and our affiliated consulting firm, the ACTA Group, is take new technologies in this space, newer, better, cheaper, greener chemicals and technological platforms, and try to get them into commerce and navigate through the maze of chemical regulatory approvals occasioned by 2 of the statutes that we're going to talk about today. The first of which is the Toxic Substances Control Act, and thereafter we'll move into the Federal Insecticide, Fungicide, and Rodenticide Act, affectionately known as FIFRA. Okay? So I do want you to at least be aware of all of the content that is embedded on our website. Also, ELI has a wonderful boot camp later on this year, and lots of other products, programs, and services on its website. So don't miss those. Okay, so if you have attended any of the other summer programs, you probably are now familiar with air, water, waste, and some of the more traditional environmental control statutes. The chemical use laws that we're going to talk about today are different, because we're not talking about the consequences of manufacturing smoke up the stack, water, effluent, or the cleanup of those materials under the Resource Conservation Recovery Act and or Superfund. We're talking about the regulation of the meat specific chemical, either under the industrial context, which is regulated under the Toxic Substances Control Act, or in some instances, the same chemical, but used as a pesticide and regulated under the Federal Insecticide, Fungicide, and Rodenticide Act. So these are chemical use laws, and they're really important, and they're very old, and there is a lot of law, lore, and legend around each. So we're going to try to keep this very general and come at it from the perspective of what are the key topics, how do they relate to one another, how do they relate to chemical use laws throughout the rest of the world. Caitlin mentioned a couple of them, REACH, and there are REACH-like programs now in Korea, Turkey, China, and elsewhere. And we deal with them all because the world is about this big. And if you are the legal representative of a new technologist or a new technology, you need to look at the regulation and development of that technology, not from the perspective only of the United States, but how does that technology fit in the intergalactic universe? Because it's going to be regulated in China, it's going to be regulated in Turkey, it's going to be regulated in Russia, it's going to be regulated in India. So you need to be thinking of all of the regulatory programs that apply to that in order to get it into the market and optimize it as a new invention that we hope is better, greener, cheaper, whatever, more sustainable than perhaps the incumbent that it's replacing, okay? And by all means, if you have any questions, just put your hand up because it really helps enrich our conversation. We're only going to talk about 2 chemical laws. There are many other laws that touch consumer products and products generally, and I've just identified a couple of them here. We're not going to talk about any of them, okay? But the Federal Hazardous Substances Act, the Consumer Product Safety Act, and the Consumer Product Safety Improvement Act. The Federal Trade Commission has a dog in this fight because it regulates green claims asserted by chemical manufacturers or product manufacturers with respect to the greenness, sustainability of the products. The California Safer Consumer Product Regulations is a very important new program in the state of California. You know, a lot of people roll their eyes back when talking about California. California has a lot of very innovative, forward-thinking regulatory programs that kind of set the tone for not just other state regulations, but even federal regulations under other administrations other than this one. But in any event, there's a lot going on in California with respect to product regulation and the presence of chemical substances embedded in these products. And every state has a state consumer protection law, similar to the federal consumer protection law. They're all different, but they all touch the chemical product and product use space. We're not going to talk about any of them, but just be mindful of these other laws. If you are in practice one of these days, either as a consultant or as a lawyer, there are many different elements that go into the regulation of products, okay? So first we're going to talk about TSCA, the Toxic Substances Control Act. It is the key federal law that regulates neat chemical substances. And by neat, I don't mean like, oh, hey, that's neat. I mean neat, meaning the pure chemical substance, okay? As many of you know, it was originally passed way back in 1976 after lots and lots of debate. That was the same year that another federal law was passed. Anybody want to hazard a guess? RCRA was also passed in 1976, the Resource Conservation Recovery Act. That law, TSCA, went almost 4 decades without any substantive amendment whatsoever with respect to Title I, which is the title that deals most specifically with chemical regulation, which is an astonishing statement when you think of all of the advances made in chemicals, what we know about them, how they're used, what they might do with respect to exposure to human health and the environment, technological platforms, the evolution of nanotechnology, nanoscale materials. So 4 decades went by. And interestingly, too, as many of you may know, TSCA was thought to be somewhat flawed just about the minute it was signed into law. It was always intended to be the law that fills in the gaps and fills in the areas that are not regulated by other federal laws like the Air Act, the Water Act, Superfund, RCRA, endangered species, and all of those other federal environmental laws that you all know so much about. TSCA was intended to be kind of the utility infielder and address areas not addressed by those other statutes. But it was, and we'll talk a little bit about what some of its key handicaps were and why about starting 10 years ago, there was a resounding chorus of demand for TSCA reform. And we'll talk about the reasons why. But that reform came in the form of the Frank R. Lautenberg Chemical Safety for the 21st Century Act, which was signed into law on June 22nd, 2016. So a little over 2 years ago, TSCA was pretty extensively revamped. And so for those of you that are looking for a career, that are looking for opportunities to be in a space that represents the intersection of law, public policy, science, this is it. Because TSCA, the new TSCA implementation is a fascinating fight, if you will, between many different stakeholders in implementing a law that was penned just over 2 years ago in haste by a bipartisan Congress months before Mr. Obama left the White House. So it has all the makings of a wonderful drama. I'm waiting for that Netflix series to come out. TSCA, what's next? I need to get a life. Okay. As I said, TSCA provides kind of a chemical safety net. It's one of several statutes that really regulate chemical substances. It's very, very focused on industrial chemicals only. So if it has an agrochemical or pesticidal potency, TSCA doesn't apply. These are industrial chemicals. And the new TSCA has really changed a lot of different pieces of the regulation of industrial chemicals. Some really good changes, other changes, not so much. Well, what is the purpose of TSCA? Why do we have this chemical regulatory program at all? Well, I've tried to highlight in red here what are the real drivers behind the original TSCA and as reinforced by new TSCA. It was to encourage the development of adequate information for the United States Environmental Protection Agency, which has jurisdiction to implement and enforce TSCA, to provide that agency with sufficient information to inform their judgment about the risks and benefits of industrial chemicals, okay? It's also intended to regulate chemicals and mixtures, which are just one or more chemicals mixed together, that might pose, and this is the key legal standard, an unreasonable risk to human health and the environment. And what is unreasonable? It's not any risk, it's an unreasonable risk. So right there, this statute allows some risk, but risk to the extent that it doesn't pose an unreasonable one. And of course, right now, the definitions of what is unreasonable versus what is reasonable is, of course, where much of the action is at. And importantly, Section 2B of the Act, as originally enacted and as reauthorized 2 years ago, Congress wanted to make real sure that the regulation of industrial chemicals was not so extensive that it should impose an unduly impede or create unnecessary economic barriers to technological innovation. I really just want to read this little paragraph here so everybody gets a sense of what EPA is always tasked and trying to balance. Authority over chemical substances and mixtures should be exercised in such a manner as not to impede unduly or create unnecessary economic barriers to technological innovation, while fulfilling the primary purpose of this act to assure that such innovation and commerce in such chemical substances and mixtures do not present an unreasonable risk of injury to human health or the environment. So that's one of those guiding principles that Congress was real clear on. We need to regulate chemicals. We need to make sure they don't present unreasonable risk. But on the other hand, we need to make sure that we're not impeding technological advances in a way that might frustrate, thwart, or impede innovation. So it's a very, very difficult balancing act, and I know EPA struggles with it, but it's an important one to keep in mind during the course of this presentation. So we're going to go through a couple of key provisions of the act, and we're going to do so in a way so you can see how they each build upon one another. And I'm going to try to present this from the perspective of both what are the really cool policy issues going on right now at EPA with this new administration, and Congress, which implemented or wrote the law a few short years ago, but also from the perspective of if you are a lawyer and if you are not doing this every single day of the week, 24/7, as I do, what are the key areas that you should be mindful of? Because a lot of these TSCA issues, for many of you, you're not going to be able to pick a TSCA significant new use rule out of a lineup now or later in your career, right? But you might be in the context of a due diligence. You might need to know what areas to look at. Your client or company might be a subject of an audit by EPA inspectors. So what are the big issues that you should be at least generally aware of? So we're going to talk about testing of chemical substances. Section 5, which is a shorthand way of saying new chemical substances. Section 6 are existing chemical substances, and there's a big difference between the two. Section 8, record keeping and reporting of information. Record keeping is hugely important in TSCA because it cuts a very wide swath, and it's fish in a barrel time when it comes to enforcement, okay? Section 9 is relatively important in areas that we're probably not going to touch much on. And 14, CBI, confidential business information. Remember, TSCA preceded the right to know movement. The EPCRA came out in 1986, TSCA came out in 1976, and now everything is right to know, right? There's a constant tension between maintaining the integrity and confidentiality of your magic pixie dust, which might be a brand new chemical innovation, versus consumers and the public's legitimate right to know about what that substance is and what might be a potential, pathway to exposure. So harmonizing those two competing but very important legal principles is all about confidential business information, section 2014 rather. And then finally, administration of the act, which is a very big section of the new TSCA, the Lautenberg Act, signed into law 2 years ago, which has many different interesting twists and turns and requirements of EPA that we'll talk a little bit about. Okay, what is a chemical substance? Well, it's very broadly defined to include anything pretty much except pesticides, food additives, drugs, cosmetics, and preparations otherwise regulated by other federal statutes, okay? So if you are dealing with anything having a pesticidal potency, whether it's intended or explicit, that's covered by FIFRA. TSCA steps in on just about everything else that isn't covered by the Federal Food and Drug Administration as a food, drug, cosmetic, or food additive, or as a pesticide now under FIFRA. So it's very broadly defined and excludes anything regulated by another federal statute. Okay. Now, some chemicals can be regulated by both. You can have acetone as a solvent chemical regulated under TSCA, but that can also be used in other contexts and be regulated in other ways, depending upon the use by EPA FIFRA office or FFDCA, Federal Food, Drug, and Cosmetic by FDA. So you need to always be mindful of the use of a chemical to figure out what bucket it belongs in, because it can belong in any of them, but it can't belong in the same bucket at the same time, okay? It includes manufacturers. So we do a lot of work for the chemical manufacturing, the Dows, Solvays, DuPonts, Monsantos of the world, people that produce chemical substances. And whether you produce it here in the United States or if you import it from Asia or Europe or any place else, once that chemical hits the US entry, you become a manufacturer. So it covers manufacturers and importers and processors. So you can get a chemical that's manufactured by somebody upstream of you, and you buy it, and you mix it up with something else into some other preparation, you're still subject to TSCA. So it's not just a chemical manufacturer statute. It includes importers and processors as well. Now, TSCA also distinguishes between new and existing chemical substances. Way back when TSCA was first signed into law back in '76, Congress had tasked EPA with providing a long list of every chemical in commerce at that time. Why? Why do you think it mattered? Anybody, just take a wild guess. EPA needed a baseline. It needed to get a sense of how many chemicals were in commerce at that point in time. And every chemical that was reported by the manufacturer importer got slapped onto a list called the Chemical TSCA Inventory. It's just what it sounds like. It's an inventory of chemical substances. And chemicals that are on that list are considered existing. And the value of being an existing chemical substance back then was that you were grandfathered. You were deemed to be, you're in commerce, you're on the list. And so your continued use, processing, distribution, and commerce was perfectly okay. And there was no de novo review by EPA as to the potential hazards posed by those chemical substances that were on the list. So the way the law was intended is that existing chemicals were on the list as of 1976, or really when the implementing regulations came out in the late 1979, 1980 timeframe. So you're an existing chemical substance, and if you were manufacturing or importing or processing that chemical, you're good to go. No problem. And of course, we know now that some of those chemical substances probably posed risks in ways that were not anticipated, nor was there any independent review of those chemicals. But EPA had the authority under TSCA Section 6 to assess the hazards posed by existing chemical substances, but for a variety of reasons, largely because TSCA in its old state provided EPA with authority to review existing chemical substances, but there was really no mandate to do so. And as we all know, for those of us in the space in any event, when EPA tried to ban asbestos under the old law because of the Herculean legal burden imposed upon EPA to demonstrate that asbestos posed these unreasonable risks and there was no viable alternative and there was a risk-benefit analysis that had to be done. On appeal, EPA's legal burden was found to be too high, and under corrosion-proof fittings, EPA lost that case and was unable to ban asbestos. So that case was one of the main poster children for saying the old TSCA needed to be reformed because the Section 6 burden, legal burden on EPA was so great and so impossible to achieve. We can't even ban asbestos, for God's sake. And everybody knows that asbestos in certain forms, in certain pathways of exposure, poses unreasonable risk. So in any event, it was very important, and it is very important for purposes of this discussion, is to put new chemical substances as those chemicals that are not on the TSCA inventory versus existing chemical substances that are on the inventory. Okay, it's a super big distinction. So what are some of the major changes with the Lautenberg Law kicked into law 2 years ago and 2 days ago? Well, number one, there is a mandatory duty now on EPA to evaluate existing chemical substances. So the mandate that was missing from the old law is front and center in the new law. It's like, thou shalt review high priority existing substances by a date certain and according to this schedule. And EPA had to issue rules, which it already did last year, to make that process happen. Also, chemicals assessed against a risk-based chemical safety standard with no consideration of non-risk. So in other words, the cost-benefit analysis and the standards that applied under the old Section 6 were completely revisited under the new law. And so for purposes of determining whether an existing chemical substance poses an unreasonable risk to human health or the environment, cannot include non-risk factors. It is based purely on risk, which is, of course, a combination of hazard and exposure. So in identifying what mitigating steps need to be taken once an unreasonable risk is found can include a cost-benefit component. But in terms of identifying what is an unreasonable risk, non-risk factors are excluded. So that was a big, big, big change. Unreasonable risk identified in the risk evaluation must be eliminated. So in other words, the standard under the new law is once you've identified an unreasonable risk without consideration of non-risk factors, you got to fix that risk. You have to regulate that risk until it goes away, which is a completely commonsensical, gee, if you find a problem, you have to deploy resources to the extent the unreasonable risk is gone. Okay, so it's very clear under the new law, and very important changes. And then finally, they expanded authority to compel the development of chemical information. That was another big concern that our colleagues in the NGO community, and even those in the industrial chemical community, were concerned about. The EPA really didn't have a whole lot of authority to compel tests that would tease out the hazards, inherent hazards of a chemical substance, and therefore be better able to define what is considered unreasonable risk. So the new law gives EPA unilateral order authority, which it didn't have under the old law. It was a rulemaking or a negotiated consent approach, which generally ended up in litigation. The new law also requires EPA, and this is so important for you TSCA nerds out there. We talked a lot about an existing chemical substance. You look on the inventory, the chemicals listed there, it's an existing chemical. What if your substance isn't on the list? If it's not on the list and it's not on the super secret confidential inventory, because there are really two inventories. There's one that's public, and then there's a super secret confidential inventory. And there's a way of asking EPA if your chemical is on that super secret list. But assuming it's not on either, it's on neither list, you are a new chemical substance. And so if you're an importer or you're a manufacturer and you're trying to figure out whether you have to get EPA pre-market approval to bring that chemical into commerce, either by importing it into the United States or manufacturing it down the road, if you are new, you have to go through what is called pre-market notification, or a PMN. It's a series of documents that have to be submitted to EPA scientists. Under the old law, the PMN process was infinitely easier because you submitted your PMN form, you're not required to generate data. EPA used various models to assess the hazard and risk associated with new chemicals, which it lacked information on. But it was relatively straightforward. Under the old law, roughly 90% of all new chemicals after 90 days, which is the statutory review time, were basically added to the list. So 10% of new chemicals were captured and subject to further restriction because EPA found, either through the data that it reviewed in assessing the chemical or in applying the models that it deployed to assess the toxicities and inherent hazards of the new chemical, it would attach a regulatory component to that new chemical, saying, yeah, if you're going to use it, you have to have goggles in the workplace, or respiratory protection, or full face respiratory protection, or no effluent to water. And so all effluent would have to be captured and either recycled or contained and sent off site for destruction, all of which are commercially, a little more expensive to employ. But now EPA has to make one of three findings, which we'll talk about in a little bit, which has caused chaos, is a term I don't use loosely, but it really has gummed up the works. So now about 80% of all new chemicals are being caught and regulated, and about 15 to 20% are not. So it's completely inverted the regulatory ratios of getting dropped from review and entering into commerce relatively quickly versus being snagged for regulation, being subject to a consent order, and a subsequent significant new use rule. And remember that 2B, authority over chemical substances, cannot be employed in a manner so as to impede unduly or create technological barriers. That's where a lot of the debate is right now. That's why that's relevant. So anyway, EPA has to now make one of three findings, and how it makes that finding, on what basis, and how these new terms under the new law were intended to be implemented is very, very interesting and very challenging right now. Also, EPA has brand new authority to charge a whole lot more money, and we need that. None of my clients is concerned about the fact that EPA has the authority now to assess a fee when you submit a new chemical application. There's always been a fee, but it's been relatively modest, like $2,500 or $100 if you're a small business, which is not a lot of money. As we'll talk about under the pesticide program, the fee program is significantly more robust. A new chemical or new active ingredient under FIFRA can be up to $1 million in fees. So under the new funding mechanisms in the new law, EPA gets to charge more. EPA proposed a rule a number of months ago, and we're waiting for a final rule to come out to see what the final numbers are. So it'll probably go from maybe $2,500 to maybe $14,000, just to give you a sense of scope. Okay, let's start with record keeping and reporting. Not surprisingly, information is just hugely important for EPA. So EPA scientists can review and assess the hazards and risk patterns and exposure patterns of chemicals, both new and existing, and needs information. So EPA the Act authorizes EPA to require chemical manufacturers and processors to maintain a whole bunch of different records. We'll talk about what those are. An important one is TSCA Section 8E. It's a very important requirement that requires companies immediately to notify EPA of substantial risk information. So when the shorthand notification is, well, we have an 8E reporting obligation. If you newly learn information relating to a substantial potential risk posed by a chemical, whether it's a toxicological, too many bunnies died in a toxicity test, or in an environmental release context, something happened that you didn't think would and did, you have to report that immediately. And EPA takes this exceedingly seriously. Many of the more celebrated TSCA enforcement actions have revolved around failure to report 8E information, because EPA takes a position, if you are a chemical steward and you learn something that you don't think EPA knows, and it's not otherwise exempt for one of the reasons set forth in the regulations, you need to report that immediately, because your failure to report it could cause harm to humans, workers, and others. The law also requires that chemical manufacturers and others maintain records when there are allegations of adverse effects given to them, either by an 800 line, or an employee might come in and just say, I think I developed a rash as a result of an exposure to this chemical, or any allegation is broadly defined. So there are different set of requirements. And EPA can also, under the law, compel the submission of information that you have in these files to help better inform EPA as to whether multiple manufacturers of chemicals that are related or in the same class are giving rise to patterns of adverse effects that need to be regulated. So here's just a schematic of these various reporting obligations. I tried to keep it simple and break it down, but 8A, it gives EPA authority to tell chemical manufacturers that it wants information relating to production, use, and exposure of chemicals. There's another reporting obligation that comes up every 4 years called the Chemical Data Reporting Rule, or CDR, and it applies to companies that make more than a certain volumetric amount of a chemical at any one site, and you have to submit a bunch of information that, again, helps EPA identify whether or not chemicals are posing unreasonable risk. It's a very important part of the regulatory program here. 8C, those allegations of adverse health effects submitted to EPA. 8D, if you have a health and safety study, a lot of companies voluntarily generate data on chemicals that they manufacture. And EPA has the authority under the law to compel the submission of those data upon request. And of course, 8E, the immediately report requirement, if you have information that you believe is substantial, doesn't fall into an exemption, and immediately means immediately. So these are all very important on the enforcement side, because not surprisingly, you either have a record or you don't. You either maintained a record or you didn't. You either submitted your CDI report for all the chemicals you produce or you didn't. So it's very easy to assess non-compliance with record keeping. And because EPA relies upon this information to help build a robust program, these reporting obligations are taken very seriously. What does EPA do with all this information? It just doesn't sit around in files at the agency. There are many gifted scientists at EPA that review this information carefully, and it might morph into a determination that EPA needs more information. So if available information is not sufficient, and EPA believes that there might be a pattern of a chemical or a class of chemical giving rise to either an adverse effect to humans or workers or the environment, it can compel under Section 4 an administrative order or a consent agreement to engage in rulemaking regarding more information on a chemical. So Section 4 is the authority EPA has to compel testing. And as I said before, in the olden days, under old TSCA, when EPA issued a test order, usually what happened is they'd see a Federal Register notice that based on information the agency has been collecting, it has determined that it lacks sufficient information on chemical XYZ. And so we want a 2-gen reproductive study on 2 species. We want a neurotoxicity study. We want an immunotoxicity study. We want an inhalation study. And these studies cost a lot of money. So whoever manufactures that chemical that was identified in that Federal Register notice usually forms some form of consortia to generate the data collectively, because EPA doesn't need 15 different reproductive toxicity studies. It needs one really good one. But the cost of that could be easily $500,000, $750,000. So companies would get together and work with EPA and either satisfy the Federal Register notice and the order, the rule, or it would negotiate with EPA, because sometimes there are testing protocol issues or other quirky dimensions that needed to be negotiated with EPA. And then you would enter into an enforceable consent agreement or an ECA. But often in discharging its Section 4 authority, it didn't work so well. There were a lot of lawsuits and a lot of concern that EPA didn't meet its burden in demonstrating it needed the data. So that's why under the new law, EPA has this new authority to compel testing on a chemical substance by unilateral order. And you have options in court if you disagree, but that new authority is a big deal. Also, and importantly, because as my colleague Jesse over there knows well, I'm kind of an animal freak. We have lots of animals. But the new law has a very strong bias against testing of vertebrate animals. So it's not an absolute prohibition. It fell short of that, but the language is reduce and replace such testing to the extent practicable, scientifically justified, and consistent with policies of diminished animal testing. That is the way of the world, obviously. It's long been concerned in Europe. Animal testing is verboten. But here in the United States, we're moving slowly in the direction of having much more sophisticated testing that doesn't involve animals with vertebrates, okay? And EPA had developed within 2 years of enactment, which it did meet this deadline timeline, came up a few months ago with a strategic plan to implement testing protocols that reduced or replaced animal testing. So that's a really good thing. Okay, so EPA gets this information, say, for example, on existing chemical substances, all of this 8A, 8C, 8D, 8E information. It issues maybe a test rule under Section 4, and it gets additional information, it has all this information. So it is allowed under TSCA Section 6 to use that information to determine whether or not an existing chemical substance poses some sort of unreasonable risk in a way that needs to be abated, okay? So Section 6 authorizes EPA to address unreasonable risk through restrictions, bans, warning requirements, record-keeping requirements, use restrictions, and other means. And remember what we talked about, what that standard is, until that risk is abated. So Section 6 gives EPA very broad authority to implement measures to prevent risk. Now, how is, there were on the inventory before it was reset about 85,000 chemical substances on the list. Does that mean there are 85,000 chemicals in commerce? No. I think by our count, it's more like 55,000. It's still a lot, don't get me wrong, but there are not 85,000 chemicals in commerce. Many of them have been discontinued. Some of them may not have ever been commercialized. But for one reason or another, that list is a smaller universe. Now, how does EPA go about identifying what chemicals should be reviewed first? Because now under the new law, right, EPA has an affirmative duty to review all existing chemical substances. How does it prioritize? Well, EPA under the new law divides chemicals into two buckets, so-called high and low priority substances. High priority substances are those believed to present an unreasonable risk to injury or health due to potential hazard and route of exposure, including susceptible subpopulations, a term of art defined and new to the new law. And a low priority is anything that isn't a high priority, okay? So EPA issued a rule June 22nd, 2017, 1 year to the day after Lautenberg was signed, that set out a process for prioritizing substances. Because, you know, with all those chemicals out there, you need to prioritize them. So that rule is now being litigated. There was a lot of concern with whether it went far enough and so on and so forth, but all of the key framework rules that are derivative of the new law are now in litigation in various circuits around the country. We're not going to go into that, but just recognize that the existing chemical risk evaluation rule and priority setting rule and inventory reset rule are all in federal litigation. So EPA identified 10 substances as their first high priority substances, and they're really more or less pilots on how this risk evaluation process that is new to the new law is going to be used and implemented. And not surprisingly, the 10 chemicals are very data-rich substances. These are substances that have been around a long time: trichloroethylene, TCE, tetrachloroethylene, and methylpropylidone or NMP, methylene chloride, asbestos, HBCD. So these are chemicals that EPA knows, based on the information available to it, have hazards associated with it, a lot of information on which to deploy its new risk evaluation rule, derivative of the new law. And then when one of the 10 is done and fully evaluated, and risk mitigation measures are imposed or not, depending upon what the conclusion of the rule says, then another one will be added. So it will always be populating this list of high priority chemicals that are going through this process of review by EPA. So that's how the new law is intended to actualize the concern with the old law, that EPA had all this authority, but there was no mandate to discharge it because there was no deadline on or before which chemicals were to be reviewed, just that EPA had the authority to do so. So the new TSCA under Lautenberg fixes all that. It says you're going to review all existing chemicals. You're going to start with high priority chemicals. You're going to do it within a date, by a date certain, within 3 years. You're going to do it by this process, and you're going to regulate until whatever hazard you found under the risk evaluation has been abated. So it's pretty commonsensical in my view. The safety standard is still risk-based as it was under old TSCA, but again, you cannot, in making a unreasonable risk determination, rely upon non-risk factors. You have to exclude any of those considerations. And risks to susceptible and highly exposed populations must be considered, and that was not explicit under the old law either. And what might be a susceptible subpopulation? Just take a guess. Yeah, I heard children. Yes, children, infant, the elderly, pregnant women, and what is a susceptible subpopulation? Workers. So workers were added to the cohort of susceptible subpopulations, risk or exposure to which must be now specifically included in this risk evaluation for both existing chemical substances under Section 6 and new chemicals under Section 5, okay? And again, as we talked about before, EPA must take risk management actions to address those unreasonable risks. And cost and available alternatives can be considered when you're selecting risk management options, but not in the determination of whether or not an unreasonable risk exists in the first place, okay? And there are, of course, exemption processes for so-called critical uses, but as you can imagine, they're going to be really, really hard to exempt your way out, because the critical uses is there's absolutely, positively no other alternative at all. So really hard to get out of. So this is just a little schematic of the final risk evaluation process rule that came out about a year ago. And I won't go through it here, but it is just very stepwise, very logical, time certain, regulate it till the risk goes away, and that's that. And there are, not surprisingly, all types of administrative and legal remedies if you should disagree with the EPA or if new information becomes available. We're not going to go through that, but for the lawyers in the audience, recognize that there are remedies if there is significant disagreement as to whether something is or is not an unreasonable risk, and that a particular risk mitigation option or mitigation measure should or should not be selected, okay? There are special conditions that apply to so-called persistent bioaccumulative and toxic chemicals, or PBTs, not surprisingly. We know a whole lot more about PBTs now than we did back when TSCA first came out, like PCBs and stuff like that. And EPA has a way of short-circuiting the risk evaluation process by basically saying no risk evaluation and only a use and exposure assessment is required for chemicals that fall into this category. So just recognize there are special provisions that apply to PCBs that make it, or PBTs that make it easier for EPA to assess and regulate. We already talked about the TSCA inventory, but this is a segue into this new Section 5 process, which I can't emphasize enough how both fascinating it is if you're a scientist, a chemist, a lawyer, a technologist, an innovator, an entrepreneur. You've got a brand new chemical and you really think it's going to be the next best thing and it's going to replace everything that's bad and evil in the world, and you just want to get it into commerce immediately. This new process is what you got to go through if you're an industrial chemical. So again, you say, for example, you represent a company and they call you up and they say, oh my God, we've got a fantastic innovation, but I didn't see it on the inventory. You run the traps at EPA and EPA confirms that it's not on the confidential inventory. So it is by definition new. Now there are exemptions to what is considered new, right? You can be a research and development product. There are certain polymers are exempt from regulation and need not be subject to notification under Section 5. There are other exemptions, but we're going to just assume that this is a commercial chemical. It's not exempt. It's not on the inventory. It's brand spanking new. That means you got to submit a pre-manufacturer notification. There are also lesser opportunities for exemption by smaller amounts, the so-called low volume exemption, 10,000 kilos of a chemical per year. So there are these exemptions, but we're talking about just a chemical that is new, doesn't qualify, isn't on the inventory. So what do you got to do? You have to submit this pre-manufacture notification, and it is just what it sounds. Before you can import it or manufacture it for a commercial purpose, R&D is okay. But for a commercial purpose, you have to submit this notification to EPA. And this is just a very shorthanded way of telling you what the information is. Chemical identity, the structure, the volume. Volume is super important. Intended categories of use. So if you're going to be using it as a plasticizer that might ultimately go into products that involve children, or if you're going to be using it as a chemical intermediate and the cohort of exposed entities might only be protected workers, this is going to have a huge difference on EPA's evaluation of the potential risk posed by that chemical. That's why EPA teases all this information out. And this is why we have 7 PhD organic chemists on our staff, because this stuff is hugely important. Chemical identity and the use pattern to which a chemical might be put. So EPA conducts a review, and remember, EPA is supposed to do all of this in 90 days, which is a flash. If you're getting hundreds of these submitted, 90 days is not a lot of time. But EPA does, they have a very gifted team of scientists, exposure assessors, and others that have a very well-defined process over the years that, of course, has been changed a lot over the last 2 years. But it has to evaluate the health effects, the environmental fate properties, and establish what type of hazard and what type of exposure pattern might need to be reviewed to determine whether or not this new chemical could pose an unreasonable risk under some use scenarios. So now EPA has to, in this very new process that was born on June 22nd, 2016, make one of 3 determinations way up at the front there and within this 90-day period. So it has to determine whether the new use, and there's another term of art we use here, a significant new use of an existing chemical, which could be considered a new chemical. The process is the same, okay? So if you have a chemical that is regulated by EPA that disallowed a certain use of a substance by virtue of a significant new use rule, if you wanted to use that existing chemical in that new use that is disallowed because of the SNR, it's basically considered a new chemical for that use. And so if you have a brand new chemical that's never been regulated, or if you have a significant new use of an existing substance that is regulated, EPA can determine it presents an unreasonable risk, period. Full stop, game over. It presents an unreasonable risk. You don't want that determination by EPA. Number 2, available information is insufficient. EPA simply lacks sufficient information to make that determination. Or 3, the new use or the significant new use is not likely to present an unreasonable risk, which is, of course, a determination that you want. That is not likely, falls out of review, you're good to go, life is grand. Most chemicals are falling into the 2 bucket. We lack sufficient information, so how do we bridge that gap in a way to get the chemical into production? And usually it's being done not by the generation of data at the front end, but rather the limitation of uses or manufacturing limitations or worker health and safety requirements when the chemical is being used either in the manufacturing context or by downstream users or even downstream users of downstream users, okay? And that is embedded in a consent order that you negotiate with EPA, which dictates the terms and conditions that allow you to use a new chemical subject to these limitations. So the process that has been going on has been a difficult one for EPA. EPA is working very, 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 very hard. It recently came out with a revised points to consider document to help chemical innovators satisfy the requirements of a really well-documented pre-manufacturing notification, so EPA has the information it needs, and so it doesn't have to go back and keep asking questions and extending that 90 days. Not surprising, in the legal profession, there are lots of smoke and mirrors, right? Nothing happens in 90 days. We stay the 90 days and then extend it, and you can extend it many, many times. So many of our chemicals have been pending for 1.5 years, 2 years. And if you have a lot of money and investment on an infrastructure to generate copious amounts of a new chemical and you don't have approval to do so for an indeterminate period of time, not surprisingly, that causes commercial chaos, which is why we were working very closely with EPA, those of us in the TSCA sector, to have a well-defined, credible, scientifically defensible, but predictable system so we can get chemicals that are meritorious of their commercial use into commerce in a way that doesn't unduly impede innovation, but doesn't pose unreasonable risk to human health and environment. So that's delicate balancing act. So that was a whirlwind tour of TSCA. We can pause just briefly now and let me take a drink of water while you ask some questions.
We have a few.
All right.
So a reminder to those online, you can submit questions using the choose question box. The first question is, what is the rationale behind the distribution of pesticides with no impact on the types of hazardous?
I think the rationale, the question is, why are pesticides excluded from TSCA? And the answer is, if a chemical is being used, marketed, explicitly or implicitly for its pesticidal properties, it's got its own statute to deal with, and that's called FIFRA, which we're going to be turning to momentarily. But you don't want a chemical to be regulated under both. TSCA addresses unreasonable risk
what information in general is public about TSCA, and how is it decided what's going to be public and what's not?
Under Section 14, not EPA, but TSCA under Section 14 allows companies to assert confidential business information with respect to the chemical identity of their innovations. And that's done for a whole host of reasons, not the least of which is they spent a lot of money developing this and they don't want reverse technology or reverse engineering to find a way. So you can mask the chemical identity of your proprietary innovation, and EPA does and will assign a different chemical identifier for that substance. But if you truly don't know if something is on the inventory because it is on the confidential side of the inventory, you submit what is called a bona fide intent to manufacture, or you submit information to EPA that is what was on the screen for the PMN to say, I want to manufacture this. I don't know if it's on the inventory. It could be on the inventory because it might be on an inventory in another country, Europe or China or Asia or Japan. And within a very short period of time, EPA will come back and say, it is on the inventory. You don't have to submit a PMN. So the new chemical innovator can go on, rely upon the information EPA has given it, and the chemical identity of the chemical that is on the confidential inventory is maintained. EPA does a very good job of protecting CBI. The protections for CBI are much less today than they were in the beginning of time back in '76 because of, remember we talked about the clash between two competing interests, right to know as a consumer or even a manufacturer or processor of the chemical, and the right to maintain the confidentiality of your chemical innovation that you've spent millions of dollars perfecting. So that balancing is a difficult one, and the new law puts many more restrictions on your ability to assert CBI. For example, in the olden days, you just said CBI, confidential business information, end of story. And if you submitted a FOIA, Freedom of Information Act, seeking that information, the burden was on the person seeking the information to prove up that it needed it and that it really wasn't confidential. Now you have to affirmatively corroborate your assertion of CBI at the front end, and your ability to assert CBI is now limited to 10 years, after which time you have to re-up or you lose the confidentiality protection. So that the universe is smaller, the burden is greater, and you need to be much more disciplined. I know when clients come to us and say, well, can I keep this out of public circulation? And then we go through a long list of questions. Well, is it publicly available in another country? Is it on your safe to data sheet? Is it on your marketing material? And if the answer to any one of those questions is, well, yeah, then you can't keep it CBI because it's already out. So it's a much more disciplined process now, and a new area of the law is asserting confidentiality, maintaining confidentiality, and ensuring you don't lose confidentiality, because these data are highly, highly valuable, and you can monetize those data in other jurisdictions by relying upon those data and monetizing them for new chemical submissions in other countries. So maintaining this is a big deal, a much bigger deal now than it was even 10 years ago. Any other questions?
We have a few more. Do you want to take
Sure,
them
sure.
now or at the? Okay.
Yeah.
So we have one from online. That's, you discussed manufacturers' obligation to share safety information with EPA, but does TSCA require manufacturers to gather such information other than what EPA requests during its review?
Does TSCA require manufacturers to share information beyond what EPA seeks in a Section 4 context, for example?
Does it require them to gather information beyond what the EPA has requested during the review? So past its review or going forward?
Well, you have continuing obligations to share information under 8E.
Mm-hmm.
You have potential continuing obligations under TSCA Section A for chemical data reporting obligations. It's every 4 years. It's an ongoing, repetitive requirement. So if you have new information generated between the years that the agency might seek, you have to submit that. There's a continuing obligation to submit information if EPA issues what is called a PAIR rule under 8A. It might seek information, but that is usually done through a Federal Register notice saying manufacturers of this chemical, we're seeking this information, please submit it by X date. And then that usually is a flag that there is something kind of funky with that chemical, and it might evolve into a Section 4 test rule or some regulatory control because the agency has identified something that might need regulating with regard to that chemical. So there are many opportunities for EPA to solicit information that you have but are not required to submit unless and until the agency issues a rule or requests it in another context. But the big obligation is a continuing obligation to submit 8E information. So if you do a new test, if you did a reproductive toxicity test and the information is not exempt because it's already known to EPA and you have reason to believe this is brand new information, you have to submit that by operation of law. Even if EPA didn't ask for it, you have to submit it to EPA promptly, immediately, yesterday. Okay?
Do we have any other questions in the room? I think we'll take just one more online and then save the rest for the end. Let's see. When does the unduly impede innovation standard come into the analysis of EPA in reviewing chemicals?
That is a fabulous question, because to my eye, it's not so much a point in time, but just a overarching consideration that really has kind of lacked contextual application in any meaningful regulatory sense. I mean, we under old TSCA, EPA had an actual provision on the PMN form that talked about pollution prevention. In other words, if your new chemical that you specifically designed and you engineered it in a way to engineer out some icky component of an incumbent chemical, you really wanted to tout that in the pollution prevention part of your submission, because you wanted to educate EPA that this chemical might have, this or that, ward associated with it, but at the end of the day, it's way better, more effective, less toxic, more sustainable, and more effective than that which it is designed to replace. And that meant something. I mean, that was important information that might allow EPA to give it the benefit of the doubt in terms of whether it was going to be dropped from review or it was going to be snagged for regulation through a consent order or a significant new use rule. But that pollution prevention component is really not as much a meaningful part of the review now. So some of us are really kind of struggling to make sure that when we present a new chemical to EPA, we make all of those arguments at the very beginning, even at your pre-notice or your pre-submission meeting. The agency invites chemical manufacturers into EPA, if it has a new innovation, to talk about it. Talk about how it's made, why it's a great new innovation, why the agency should be really excited about this new, better organic chemical that offers less VOC, doesn't require energy or hot, water in certain applications. So it's sustainable, it's better, it's cheaper, it's more effective. You want to make that a part of your narrative at the very beginning when you're telling EPA that this is why it matters, because it might help EPA understand the value and realize that you don't want to unnecessarily impede the innovation of newer technologies in ways that contravene 2B, Section 2B in TSCA. But there's no kind of one provision. It just has to be, to me, a very important part of the narrative, a very important part of your pre-manufacturer notification, which is usually a very substantial submission, and a very important part of what you make known about why this chemical matters, why it is essential, and why it ought to be approved, even if it does have a little bit of aquatic toxicity associated with it. Because that aquatic toxicity might be way less than the aquatic toxicity posed by an existing chemical that was never reviewed, but because it's never been reviewed, an existing chemical substance doesn't face the regulatory challenges that new chemicals do. I mean, there's a name for this. It's called the new chemical bias, where because EPA has way more authority to look hard at chemicals entering commerce than it did 40 years ago when it was basically grandfathering of all existing chemicals with no review. So it's part of the narrative, it's part of the submission, it's very much a part of the data. You need to support that and then make those concerns and those benefits and those pollution prevention attributes and these superior qualities known to EPA so the scientists there can understand what they're looking at. And then the agency says, no, unreasonable risk, that's when you roll out but wait a minute, Congress said not to impede innovation. And how do you balance these competing interests? It's tough. This is a brand new law that Congress issued in haste, and EPA had a very compressed period of time to get final rules out. So, you got to give the agency a lot of credit for doing Herculean work in the 2 years that it has had since June 22nd, 2016. But there's much more work to be done, and these very, very, very difficult balancing acts are hard. They're hard to make. So why don't we move on to my other favorite statute? That would be FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act. We all love pesticides and we all hate them, right? Okay, first off, who implements the program? EPA. It's a separate office, the Office of Pesticide Programs across the river in Crystal City. It's organized into all these different divisions that we won't go into, but recognize there is a tremendous reserve of expertise, scientific expertise in the scientists and regulators at OPP. We have great respect for the men and women who have been in that office for many years. A little concerned about a lot of people leaving the agency, either by attrition or retirement or whatever, because they have a lot of work to do and there are not a lot of them to do it. FIFRA is a federal preemptive statute. The EPA has exclusive jurisdiction to approve new chemical actives and pesticide products, but some states have very robust add-on statutes. So it's not good enough just to get a federal approval on your new active ingredient or your new formulated product. You have to get a state registration as well. And in maybe 90% of the states out there, out of our 50 states, maybe 90% of them are just intended to raise revenue. So you get your federal label, that is literally a label, get your federal label on your product. You have to get your companion state label to market any pesticide product in every state. But most of them, it's a couple $100. It's an annual requirement. So maintaining those state registrations is a very big regulatory obligation that sometimes people kind of forget about. And you might be marketing a pesticide without a current state label, but it's a couple $100 depending upon the product, and it's intended to provide a revenue stream to the state agencies implementing these programs. But some states, not surprisingly, our friends in California, New York, Florida, have a very high water table, very concerned about land application of agrochemicals because of degrading the groundwater, have very sophisticated additional requirements. So whenever we go through this, exchange with clients that got a brand new fungicide, they've spent 10 years developing it, they've spent $50 million perfecting it. So we go through the federal process, and it's like, oh, that's not so bad. It's like, and then you have to get state labels in every state in which you intend to market or sell or otherwise commercialize your product. And in California, you have quite additional regulatory, they have their own tests and their own way of doing things. So you have to tack on another 8 months, a year, depending for that process. And these state requirements are becoming more robust as states are finding that they have their own issues because there might be state-specific groundwater issues or land use issues or soil conditions or whatever. So you have to be mindful that it's a federal program, but you got to get your ticket punched by every state. So what is a pesticide? Remember, we talked about what is a chemical, an industrial chemical as being very broadly defined. Well, similarly, a pesticide is very broadly defined. And for a reason we'll talk about, you can have a pesticide when you kind of didn't intend it, but you're marketing it as such. And so it becomes a pesticide by operation of law. But it's any substance or mixture of substances intended, that's the operative term, it's intended for preventing, destroying, repelling, or mitigating any pest. So a substance is considered to be intended for a pesticidal purpose, and hence it grants FIFRA jurisdiction, requiring registration under FIFRA if the person who distributes it, sells the substance, claims, states, or implies that the substance can or should be used as a pesticide. So FIFRA is very much an intent statute. And that's why the wording of your marketing material, the wording of your label is very, very important. Because if you're kind of wink, wink, nod, nodding that this chemical might, in fact, get rid of those nasty skeeters, but you don't intend it to be a pesticide, it's going to be regulated by EPA as a pesticide because you're intending that the substance implies that it has a pesticidal potency. And a lot of, I remember many, you guys are way too young, but years and years and years ago, there was a company called Avon, Skin So Soft, that it had a pesticide repellency potency to it for reasons that Avon never intended. It just did. Skeeters didn't like the stuff. So you put it on to make your skin so soft, and the skeeters went away. And so when Avon started actually embedding that, and oh, by the way, it's kind of like those drug commercials, like you may not intend to lose weight, but if you take this drug, you will lose weight. Here, you didn't intend to apply this stuff to keep the skeeters away, but guess what? It will. You're intending it, you're communicating that, and you're going to be subject to FIFRA jurisdiction by virtue of that expressed intent of the pesticidal potency of the product. Okay? So you got to be careful about that. So pesticides fall into several different buckets, and a lot of you guys you're never going to get closer to FIFRA than this presentation and going through Home Depot and walking by Roundup or Raid so I'm not going to go into excruciating detail here, but the purpose of this presentation is to help you understand how these statutes complement one another and rounding out the regulation of chemicals in the United States. And there are some other quirks that, again, given the intersection of law, regulation, and policy and science, this is a fascinating area. But all of our scientists on staff work both in the industrial chemical area and in the pesticide area because the skill sets are the same. It's a regulatory program where you have to evaluate risk through exposure scenarios and the latent inherent hazards of a chemical substance, but you just have different rules against which you need to assess these programs to ensure you can maintain these products in commerce, make money, and not mess up the environment. So there are active ingredients. I mean, how many of you use like Roundup just to get rid of weeds? You're probably all urbanites and don't have front yards or 47 acres of property to deal with in the country. Well, there's a product called Roundup where you squirt a weed and it goes away. It's very effective stuff, and the active ingredient in that is glyphosate. But when you look at the product label, you'll see that the glyphosate component is like 0.x%. It's a very tiny amount, and everything else in that container is considered an inert. It could include other chemical substances that don't have a pesticidal potency, but make the formulation work as intended, either to make sure that the active ingredient spreads out the way it should and achieves the efficacy that the manufacturer's intended. So the active ingredient is the special pixie dust in chemicals that you have to get registered. So in this instance, you get glyphosate as a neat chemical active ingredient registered. And then depending upon the different uses of that active ingredient with different inerts and different formulations, then you have end use products. And it's usually the end use that you buy at the store. You don't buy 3,000 gallons of glyphosate, you buy formulated Roundup, which contains a little itty bitty bit of glyphosate and a bunch of other stuff. So next time you go through Home Depot or your retailer of choice, just look at a label and you'll see that most of it is not the active ingredient. And there are a whole bunch of different types of pesticides. It's not one monolithic mass. It's what we call conventional pesticides, the big herbicides that are used to keep weeds away out in big fields of soy and corn. So-called minimum risk pesticides, pesticides that achieve certain regulatory standards and pose fewer environmental worker health and safety and human risks, and hence you get a benefit. They actually don't even need to be registered, so-called 25B chemicals. If you fall into this bucket, at the federal level, you don't have to be registered, but a lot of states require that you be registered. So it's a difficult space to navigate. But again, they're presumed to be pesticides because of their pesticidal potency, but they're so low in risk, they're considered minimum risk. There are biopesticides that are derivative of plant, animal, and certain minerals, and they too are thought to be less toxic, less environmentally aggressive than more conventional actives. There are antimicrobials, the chemicals that are usually embedded in other solid matrices to prevent the article itself from not decaying or eroding or denigrating in any way. And then so-called treated articles, which are like that plastic bucket that has an antimicrobial embedded in it, that is considered itself a treated article because it contains a pesticide, but you don't buy that piece of plastic or the plastic lunch bucket that's been treated with pesticide. You don't buy it to keep bugs away from your lunch bucket. You buy it because it protects the article itself, and how you communicate that has been the subject of considerable litigation over the years and in enforcement actions, the so-called treated article exemption, which we're not going to go in, but just recognize that there are different buckets that have different degrees of regulation, different requirements to support in terms of data development, and different costs associated with maintaining them. So far, so good. Any questions? Okay. So what is the regulatory framework? Well, similar to TSCA, there is pre-market approval. If you have a new chemical or a new active ingredient or a new use of a existing chemical, you found out that this product not only applies to this kind of weed, it also applies to this kind of. So those are considered new uses, and you have to get EPA's approval before commercializing that product. It's a risk-based safety standard, again, for non-food uses, no unreasonable risk, and for food uses, there's a reasonable certainty of no harm. And not surprisingly, how those terms have been defined, implemented, has been the subject of considerable debate. And the job of a good advocate, whether you're hired help as we are, or you're in a company that you're developing a package to get EPA to review and approve, is to have sufficient data, sufficient exposure information to give EPA the comfort that you fall within these zones of you have a reasonable certainty of no harm as that term is defined, given your active ingredient and the use sites and the applications to which this chemical is being applied. The burden is definitely on the registrant to demonstrate you meet the safety standard. And that's another important change that I neglected to mention when we talked about old TSCA and new TSCA. Under old TSCA, that legal burden of demonstrating something posed an unreasonable risk was on the government. And remember, we talked about Section 5, you have to now show that you're either no unreasonable risk, lack sufficient information, or boom, it poses an unreasonable risk. Now the burden is on the chemical producer to prove that you don't pose an unreasonable risk. So the burdens have shifted under the new TSCA law to be the same as the burden under FIFRA, which always has been on the chemical owner, the chemical developer. And there's if you just step back for a minute and look at what are we talking about here, industrial chemicals have are thought to not have kind of a potency, a biological potency. They're used for a particular purpose, often Most exposures occur in industrial settings where workers are protected. FIFRA, on the other hand, you are using a pesticide to kill something. So it has a biological functionality that invites very, very, very strenuous, vigorous review for all the reasons you want, right? Because you don't want chemicals out there spraying them around your dining room area for your outdoor picnic to kill skeeters if, you know, those chemicals are not safe for their intended use. So it's a very, very, very stringent standard. And the burden under FIFRA has always been on the registrant to meet these very high safety standards. And I say here, but I tell you, it's really changing. Unlike TSCA, FIFRA is use specific, not chemical specific. Because remember in TSCA, once a chemical was on the TSCA inventory, you can use it for anything, right? Unless it's restricted. Once it's approved and on the TSCA inventory, you can include it as a manufacturing intermediate. You can use it for X, Y, and Z. It was not restricted. You approved the chemical, not the use. But now, under new TSCA, given the burden that EPA insists that, well, the Congress insists that EPA make at the front end, it's becoming much more use specific. Because if you tell EPA the uses of this chemical are X, Y, and Z, EPA looks very hard at those uses and also looks beyond your uses to determine what other potential uses could be envisioned down the road. But it is becoming, the statutes are becoming much more similar with regard to the specificity of the information and the risk assessments that are becoming much more tailored to specific uses and not just a monolithic, oh, this is an okay chemical, let's put it on the list, okay? So what is a regulatory framework? Well, EPA reviews a bunch of data that are submitted according to applicable standards. And if anybody ever has a really, really down moment and you want to take a look at the Part 158 regs, 40 CFR 158 dictates the battery of tests required. And it's substantial. I mean, if you want to get into this market with a conventional pesticide, and there aren't a lot of new AIs in the conventional sense. Most of the action is in the antimicrobial and biopesticide space because it's more niche. You're looking at 5 to 7 years of developing data and millions and millions of dollars, 10, 15, 20, 30. And usually there are patents associated with these new innovations. So you can get waivers of some of these data requirements if you demonstrate that your use pattern disallows a particular adverse effect that otherwise might arise and for which those battery of tests were intended to mitigate. But at the end of the day, you're still looking at a substantial investment. And these data cost money. They cost a lot of money. And you get the same opportunity to assert CBI, confidential business information. EPA is disallowed from allowing anybody that is a multinational to like FOIA your data. You get summaries of the data, redacted, are available in data evaluation reports that might be available online, but you cannot hijack somebody else's data and take it and then submit your own application. That EPA expressly disallows that. The regulatory system expressly disallows it. But as noted here, data development can cost millions and millions, and it takes a long time to get these things through the review process. We just, as I was mentioning to some of you earlier, we just got a new AI approved last Friday night after 5 years and many, 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 many dollars. But it's good. It's a great product. So here there are protections for trade secret and CBI, and EPA is, again, like in TSCA, you really have to demonstrate you satisfy the strict legal requirements of confidential business information because of this tension between right to know. If you're a farm worker, you kind of want to know what risks you're being subjected to by virtue of this product. And I start with the position EPA wouldn't have approved it with the label instructions and mandatory requirements that it requires in applying these pesticides. So, but again, enhanced transparency is very much a part of the culture and very much a part of this space. And there's a very interesting component to FIFRA for those of you that like to litigate. How many of you are, closet litigators out there? You like a good argument, right? You like to fight over stuff. Well, we talked about, like, you have a new active ingredient. Under the law, FIFRA allows you to develop essentially a period of use where nobody else can come into your space. It grants you 10 years of exclusivity. So that's a very big investment, and it's intended to induce and invite and encourage innovation, because the law protects your development of this market in which no one else can rely upon your data to get in your space. So, and 10 years is a long time to develop a brand, a commercial distribution strategy, advertising, loyal customers. So during that period of time, nobody can rely upon your data, and the agency is disallowed from approving any additional registration similar to your registration unless you say it's okay. Okay? What happens after 10 years? After 10 years, another company can file a piece of paper and can do some tests that are specific to its formulation, and it can say, I want to rely upon that guy's data to get my registration. And so relying upon their 10 years of data development, their $50 million data package, this new guy, this Johnny come lately, can be in the market like that. But the catch is, when the follow-on, so-called number 2 follow-on registrant enters the market, they have to agree to pay compensation for the data that the first guy generated to get the original license. And that period of time, like after 10 years and a day, goes 15 years. So from the minute you get your registration to the minute 15 years passes, that last 5 years is called the data comp period. And there's a process by which parties that can't agree upon a negotiated amount, and often, sophisticated agrochemical and people in this market will negotiate either complicated distribution and licensing arrangements. So if you like that part of the law, it's a lot of fun. But if you can't agree, if the data owner says, you owe me a screen $1 billion, thank you very much, a sign here. And you say, but well, wait a minute, if we replicated these tests today, it would be $1 million. So we'll give you $1 million and maybe another $500,000 for all the brand equity you've developed over the past 10 years. So we'll give you $1.5 million. And if you just don't agree upon that amount within a time certain, you can go into arbitration. You don't go into court. You could only go into a AAA, American Arbitration Association, arbitration, and you can get one arbitrator, or what we usually do is we get 3, because if the one arbitrator doesn't like the shoes you're wearing, you're kind of, so if you get 3, you can kind of try to ensure that you're going to appeal to something up there. And you go through a trial like arbitration, where people introduce testimony, you introduce experts, it's all on the record, there's a court stenographer there. The last data comp we had was like 2 weeks. They're trial-like proceedings, and then the arbitration panel comes back with its decision. And the decision will be, well, we've looked at all of the data, we've looked at the value that the original registrant has developed as a consequence of the 10 years of exclusivity. And we've looked at the quality of the data. We've looked at the risk the original innovator, entrepreneur invited by developing this new product and pioneered the space. And we mixed it all up, and we're going to give you $1,500,000 or whatever the amount is. Now, are those judgments appealable? No, unless they are based on fraud or some other extraordinary condition that, to my knowledge, has never applied. But they're binding arbitration. And it's a very interesting, quirky area of FIFRA law that often lawyers are unaware of, because it's a very interesting mix of, again, law, policy, quantifying risk, and in economics. All of our experts are economists. from the University of Chicago that talk about, well, this is the value of that in this study, and we perfected the market here, and you've already gotten $80 billion in China based on these. So why are you asking us for more money? So it's a lot of fun if you're not footing the bill. But because they're trial-like proceedings, they're quite costly. But it's an area of the law that often doesn't come to light. And EPA, not surprisingly, is not solicitous of engaging as expert witnesses, because often we'll take the position that the data are not what they should have been if you're on the side of the follow-on, or this is the greatest study in the history of mankind and it's worth X if you're the data owner. And often you might want to get EPA's views on what it was thinking when it did X, Y, or Z in reviewing the product. So, but EPA really regards these as commercial disputes between sophisticated parties, and they just have to duke it out, and please keep us out of it. And there are lots of other administrative remedies that you can invoke that are more on the competitive side of pesticides. I mean, what is, after all, a pesticide registration? It is a license from EPA to produce and market a chemical. And all of these other relationships with so-called follow-on registrants are commercial relationships that need to be managed, and EPA prefers to be on this side of the equation, just doing the regulatory process, and you guys duke it out. But there is a very healthy component of antitrust when chemical manufacturers get together to support data for chemicals that are the same, so-called data call-ins, because once you have a chemical and you have follow-on chemicals, now you have 5 registrants all marketing a product under a different trade name bearing the same AI, just different formulations of it. And under the law, EPA has to reevaluate pesticides all the time. And that reevaluation generates what are called data call-ins. And these data call-ins go to all the registrants of the same active ingredient. And EPA encourages the chemical companies to bind together, both to diminish animal testing, right, and also be efficient in generating the high quality data the agency needs to make informed regulatory decisions. But it doesn't want 10, field trials on the same chemical. It would prefer that the chemical registrants get together. So you've got all that antitrust potential. You've got the licensing component. You've got data compensation going on over here. So it's a very rich area for lawyers that have interest in economics, commercial arrangements, distribution agreements, and of course, regulatory issues pertinent to just the review and approval that EPA is in charge of. This, I just wanted to give you, and you obviously can't read it because it's printed so tiny, but this is a copy of a label. But when you do stroll down your Home Depot aisle, pick up a can of something, and you see that tiny little print there. Every single word on that label is required by EPA. And a lot of what our non-lawyer professionals do is work with EPA on crafting the label language to do so in a way that is clear, because you really do want to communicate hazards to the users of chemicals in ways that are clear and not cluttered up. And also reflective of the true hazards posed by the chemical. I read chemical labels, closely before I apply anything, because it just seems like, well, of course you're going to do that. But I think maybe people don't always, and that's how accidents happen. But that label language is highly, highly, highly prescriptive, and it's very much required by all the rules of authoring EPA FIFRA labels. It requires elements including what are the actual ingredients. So you've got your AI, the 0.5% of glyphosate, and then the 99.5% of everything else. Those are your inerts. The approved claims, you just can't develop a product and then say any damn thing about it. Every single claim you make has to be supported by efficacy, information, and data. that you either have, and EPA doesn't usually require it, but you don't want a product out there that doesn't do what you say it can, because you won't have any customers. Use directions. How do you ensure that people are using your product in a way that doesn't invite accidents or misuse? Warning statements. This chemical will cause your eyes to burn if it gets in them, or wash your hands immediately. That stuff is real important. And registrant information. If you wanted to call somebody, call this number or see our website. And there are numbers regarding the actual registration number. That's how you can tell something is or is not a registered pesticide, because it will say EPA registration number. And if you see a product in the store that makes a bunch of claims that sure look to your eye like a pesticide claim, and you don't see EPA registration number, you're probably looking at a product that EPA would look dimly upon. And a labeling is very broadly defined, so it includes all written material. So what's on the website, what's on a product circular, what's on a shelf talker, what's on the label, what papers are embedded, the pullout on the label, very broadly defined. Remember we talked about that intent thing? So if you're saying on your website something that is not aligned with your approved claims on your label, you could get into trouble. But EPA has many more problems out there than it has time or people to resolve. So there's a lot of mischief that goes on in this space. New active product uses, the time frames, you might wonder, well, gosh, if I'm starting out, just graduated from grad school, I want to start a pesticide business. Number one, I would sit you down and talk to you like a Dutch uncle. Say, are you sure you want to do this? Because it's tough. You got to have resources to do the data, and you got to be strong to make sure that your product works and that you're going to be there for the long haul. So the way the law operates now is that if you submit an application, depending upon what type of product it is, will dictate how long EPA has to review that. Years ago, you would submit a registration application, and then you would kind of like, gee, I hope EPA gets to it pretty soon. But there was no certainty as to how long it would take for your new products, taken 5 years, cost $50 million to be reviewed and approved by EPA. So now you have the Pesticide Registration Improvement Act, PRIA, which is a statute that came into effect years ago. We're up to our going on our fourth iteration now, where if you're a registrant, you fall into one of, I think, maybe 80 different categories. Food use, non-food use, conventional, biopesticide, antimicrobial. It will give you the time frame that EPA expects to take to review that new product, whether it's a new active ingredient, which takes the longest amount of time and costs the most money, or if it's a new use of an existing product. So you've just tinkered with the formulation a little bit. You have a schedule that you can start to calibrate your commercial expectations and manage the market and your commercial business in a way that now better aligns with a schedule. Now, the schedule doesn't always come through, and EPA is required to meet these deadlines. And I think EPA does a pretty good job of meeting what is called the PRIA date, the Pesticide Registration Improvement Act, PRIA date. But if you're coming up close and EPA hasn't approved it and there's no way it's going to be able to, you can negotiate an extension. Well, what if you don't want an extension? What if it's like, I told my manufacturing people, I told my boss that we were going to have this approved because the PRIA date is August 31st, 2018. Well, the consequence of that legally is that you have to wait 2 years before you can bring an action against EPA for missing the deadline. And of course, by that time, you've been fired, the business is suffering, and you've kind of recalibrated things to move on with your life. So you really work hard to work closely with EPA to manage the product. And if you look like you're going to need more time, you don't want to tell your management the day before the PRIA date comes that you need another 3 months. Or you can, but then you quickly enter the witness protection program. Okay, so it's just like anything else. You have to manage the application and work closely with the EPA, make sure everybody communicates, and it will be fine. So depending upon what PREA bucket you fall in, it could be 4 months, can be 2 years. There's a big swing there. We talked a little bit about safer, reduced risk pesticides. EPA tries to benefit those by giving you a break on faster review times to encourage the submission of these products. And, you know, if you can, you can. If you can't, you know, you just find what PREA bucket you fall in and move on. EPA's enforcement program of pesticides is not surprisingly very robust. I think EPA probably doesn't have as many resources as it wishes it had. It has to really prioritize its enforcement actions in a way that aligns with the greatest potential risk posed by the enforcement infraction. So as I said, you can walk down the aisle, you can watch TV at 3 o'clock in the morning and see these products that promise the sun, the moon, and the stars, and oh, and guess what? They're not registered. Is EPA going to go after that? I doubt it. But it is going to go after a chemical that is being used and it's not supposed to be used for that use, or that is posing unreasonable risk, because a parallel notification, remember we talked about 8E under TSCA, I mean, you find out something, it's a substantial risk. The substantial risk provision here under pesticide law is 6A2, same deal. If the application resulted in the death of all conifer trees, and you didn't expect that result, you got a reporting obligation, and then EPA might go in to see, well, what happened here, and it might result in an enforcement action. But EPA has the authority to restrict futures inventory sales. It can issue what is called a SURO, a stop sale, use, or removal order, which means as soon as you get that puppy, that SURO in the mail, that icky certified return receipt requested letter from EPA, nothing can move. You're quarantined. So it's commercially, it's very, very potent. EPA can impose civil penalties and, of course, criminal penalties. And, you know, because of the nature of the product, EPA looks very hard at non-compliant entities. If you're using a chemical that isn't registered, if you say it's registered and it's not, if you say it's the same registered product, but you really bought it offshore in somebody's backseat or trunk of their car in Canada, and it's not that which was registered, but might be glyphosate, but not glyphosate that is registered, that's a problem. And EPA goes after these as best it can, given the limited enforcement resources that it has. What are some of the big issues? Well, you've probably all been reading in the paper about how the Trump administration and business are working together to address the Endangered Species Act. You know, the ESA has been around a long time and does need amending, no question. But we just don't want to throw the baby out with the bathwater, as it were. We like our spotted owls. But there are many issues that do need to be addressed. And so I think there are many on the Hill believing their time is now with this administration, and so on and so forth. PREA reauthorization, the Senate has been holding hostage a bill to reauthorize PREA yet again. So we have this continuous feed of fees to support the pesticide program, and the business community has relative certainty that a pesticide label or amendment or application is going to take 4 months or 2 years, depending upon what bucket you fall in. I think that's going to be done soon, but the Senate and the House have differing versions, and we're hoping that comes out before the end of the year. And there are lots of other issues with pollinators and endocrine disruptors, all of which we write copious memoranda on, that I hope people besides my adult daughters and family read on our website and on our blogs. Anything that is pertinent and relevant, we blog it pretty immediately. So anything on pollinators, ESA, endocrine disrupting, we all have it on our blog. The other thing to keep in mind too is when you're in this space, you need to be mindful of, if you want to roll a pesticide out in this country, you almost certainly want to commercialize it in Europe, in Canada, in Asia, in other jurisdictions where you can monetize your very significant investment. And what you should be doing at the very front end of the process is making sure that you're mindful of what data requirements apply in each of those jurisdictions, So you're not doing multiple long-term chronic studies because you didn't have the right protocol that would have been, with a little more generous protocol in this country, you could have satisfied 4 other jurisdiction regulatory requirements elsewhere. So part of mastering this space is to recognize what is your territory. Is it the world? Is it the United States? Or is it some subset thereof? Because harmonizing data and generating data so you can achieve mutual acceptance of data requirements is also a very important part of this space. So we have probably enough time, but anyway, we have any questions on the wonderful word of FIFRA?
So my question actually goes back to TSCA, I think, a little bit.
Oh, we're not going to talk TSCA anymore. I'm teasing.
So I was wondering about chemicals like dispersants for oil spills. Are they regulated differently because they're normally used in emergencies, for one? And then for two, are they regulated differently because they like cause an effect on the oil? Like you have like a product that comes out of it that's like sort of its own thing, if that makes sense?
Well, you raise a good point on whether one of those oil dispersant products used in, high time-sensitive emergency situations might in fact qualify for one of those really extraordinary exemptions. I'm unaware of that, but, chemical companies that manufacture products that are intended for this use site, have to go through the process too if there isn't a chemical component in a product that isn't on the inventory or is subject to a regulation, and that particular use as a chemical dispersant to be used in an Exxon Valdez type situation, it works as intended. So I'm unaware of any special consideration other than those types that if you've got the only product in town that will take care of that particular spill, EPA might find an opportunity to exempt it from more rigorous regulation, but at the end of the day, it's still a product, it's still a chemical, and that use site, especially that use site, given the fact that it might be in a water aquatic toxic environment, is going to be subject to review.
Perfect. We're going to take a question from the web, then switch back to the room. Does EPA itself issue worker health and safety requirements for chemicals handling under TSCA, or does it work with OSHA to do so, or is it some combination?
Another spot on question. That section 9 that I said we weren't going to talk about, of course, is a question where interaction with other federal statutes. EPA, for many years in the TSCA Section 5 space, does review and assess new chemicals and workplace exposures and dictates and defines workplace protections just as OSHA would. In fact, OSHA often defers to EPA because of its specialized knowledge of new chemicals and ways to protect workers from potential exposures. So as we talked about, a new chemical might have use restrictions along the lines of full face respiratory protection, impermeable gloves, ventilation to achieve XYZ, and so on and so forth, all of which are arguably subject to the same types of standards OSHA comes up with glove protection and worker health and safety standards under OSHA. There is a provision under new TSCA, Section 5, F5, where if EPA is considering imposing workplace conditions on a chemical, it should consult with OSHA. And OSHA and EPA and MSHA and NIOSH do meet monthly to talk and exchange information about new chemicals and regulations pertinent to new chemicals. So I think the best answer is it's a combination of the two, but EPA clearly, absolutely, undeniably has jurisdiction and regulatory authority to impose workplace controls in the workplace through TSCA that are in addition to workplace standards administered and enforced by OSHA. But the line between the two is a murky one.
I'm wondering if there's anything in terms of rulemaking that's been substantially different under the new administration with either of these acts, or if there's anything that you expect to change with Wheeler in charge of the EPA.
There has been considerable debate in the public space regarding the proposed TSCA framework rules that came out in the waning hours of the Obama administration and the final framework rules that came out under the Trump administration. I've been doing this a long time, and I take a much less harsh view that the comment process elicited changes that I think make the final rules better and are not politically inspired. People will disagree with that, which is why we have 3 lawsuits right now in multiple jurisdictions brought by Earthjustice, NRDC, EDF, and others, challenging whether the rules that came out of the process under the new administration fairly reflect and telegraph Congress's intent. Reasonable people can disagree. I think the final rules are sound and will ultimately be sustained, but people disagree. There are changes that have been discussed, openly. Eric Lipton's articles in the New York Times, and he's been very, very critical of the new administration. I think the administration is trying very, very hard to walk a very fine line. The new law imposes extraordinary burdens on the agency. And I think they've done a pretty damn good job of implementing those restrictions and trying to come up with a process that works. But it's still a work in progress. But the administrator, Dr. Nancy Beck, is the senior most scientist over at EPA. I think she does an extraordinary job. The Office of Legal Counsel, the Office of General Counsel does a great job. We don't always agree. And we take issues all the time, but it's always an informed, disciplined, and respectful debate on whether data are being interpreted in a way that gives expression to not unreasonably impede innovation versus protecting human health and the environment against unreasonable risk. That tension is always going to be there. But I think it's less amenable to the political vagaries of the administration than has been hyped in the trade press, but in the popular media. But reasonable people will disagree.
I think we have time for one more question in the room and one more online. Do you have one?
Yeah. I had a question about the review process for existing chemicals. It's my understanding that we have this list of 10 that we populate every time one gets finished, but that the EPA has a mandate to finish 40 by the end of 2019. I don't know if that's what I read, but I just wanted to ask, because there's only been chemical testing or safety testing done on like 200 chemicals out of the 86,000. So I wanted to ask about what you think the potential would be for collaboration, maybe between the EPA's counterparts in other countries to maybe kind of get that number up.
I think it's a very good question, and part of the reason TSCA Section 4 was amended was allowing EPA unilaterally to impose more testing on existing chemicals. EPA has thus far not invoked that new authority, to the consternation of some. Like, why isn't it? That's a good question. And the availability of other information, REACH data, for example, the European TSCA, those data, again, depending upon who owns them and how they were generated, can be used to help support either kind of a read-across analysis or a registration application. Whether international regulatory agencies are going to try to work together to generate data, probably not, but there are more pocketed, discrete opportunities through OECD and UN, various programs and voluntary programs within the chemical sector to leverage data wherever they may be to help EPA understand more about both new chemicals and existing chemicals, and trying to loosen the opportunities for leveraging those data as part of the mutual acceptance of data is an issue, MAD, testing guidelines, whether they're credible and reproducible and meet our standards. So it's complicated, but to your question, yes, there are opportunities. Those are emerging. People are being smarter about leveraging those data. And I think ultimately EPA will be more generous in its use of its new TSCA Section 4 authority more so than it has been in the last couple of years.
All right, so we'll take one more from the web.
Let's see. What does TSCA have a data requirement section similar to FIFRA's 40 CFR 158?
Well, there are test guidelines. So, for example, in the review of a new chemical, if EPA determines that we need some inhalation data, because we just don't understand if respirable particles are going to be causing lung lining damage, there are guideline studies that EPA will suggest, a 422, or that's, I think, a repro study. But in any event, there are specific studies set out in the TSCA requirements when chemical testing is required. The question is, EPA does not compel the development of a particular panel of data or battery of tests as a predicate to pre-market approval like FIFRA. So in other words, you don't have to have all of these data like you do under 158 under FIFRA in order to submit a PMN under TSCA. But if you don't have those data and EPA thinks those data are relevant and necessary, it will run it through its models and impose some very aggressive, conservative safety factors that will cause you to ultimately either engage in a much protracted debate with the EPA arguing why conservative safety factors shouldn't be used in the absence of actual data, or you're going to end up developing the data to show that you're right. Because remember, the burden is now on the PMN submitter to prove that the chemical is safe, not for EPA to prove that it isn't. So long story short, no, you don't have to develop data to submit a PMN. You're well advised to submit some data or go through some pretty fancy analyses to be able to tease out the chemical potency of the product or develop some data. And if you are required to develop data as a consequence of a consent order or a SNR, those test guidelines are set out in the EPA regulations.
Perfect. So thank you so much to our audience for joining us today and for your great questions. We hope you'll continue to think and learn about the law and policy of products regulation. This concludes ELI's annual summer school series. We would like to thank our participants who have joined us both today and for other sessions in person and online throughout the summer. We hope you'll be able to join us for programming throughout the year. An enormous thank you to our fantastic panelist, Lynn. Your vast knowledge on these topics has been fascinating and informative, and we're so glad you joined us today. Thank you all. Have a wonderful afternoon.
Thank you. You're a great audience.